On today's show, we have a very special guest. We have Matt Smith from Southpac. Southpac is a trust company based in the Cook Islands. They're one of the oldest and most reputable trust companies in the Cook Islands. Matt and I have been working together for a number of years. I'm excited to have you on the show. Thanks for being with us today, Matt.
No worries, Blake. Thanks very much for having me.
Before I get into my string of questions, is there anything you want to add about yourself or Southpac in terms of an introduction?
Yeah, sure. Just to give you the spiel on Southpac. Southpac's been operating for 40 years now. We celebrated our 40th anniversary this year. Started off in the Cook Islands in 1982, opened an office in Nevis in 2000, and we've had a presence in New Zealand since 2014. So we've got about 25 staff across those three locations, working primarily with the high net worth individual market in the US. Yeah, we've been providing premium trustee services for all that time. I'm Southpac's general counsel. I've been with Southpac for coming up to 6 years now, and work closely with a lot of our attorneys in the US and a lot of the clients there. Yeah, really pleased to be on your show today, Blake.
So can you just start off by telling us a little bit about how a Cook Islands Trust works?
Yeah, so I mean, a Cook Islands trust is, in a sense, it's a trust like any other. Like we've had trusts in the common law for hundreds of years now, but the Cook Islands has enacted specific asset protection provisions, which came online during the late 1980s. And so that gives the Cook Islands the edge over a lot of jurisdictions in terms of asset protection, because you have provisions in the law there that state that any assets that are placed into a trust, into a Cook Islands International Trust, before there's any creditor cause of action accrued against the settler or against those assets, they're going to be completely protected from any future settler claim. So it makes the Cook Islands an excellent jurisdiction for anyone who's looking to guard against any potential unknown creditor claim. You get this day one protection there. Even if there is something on the horizon, there is still a 2-year statute of limitations that applies. So anyone placing assets into a trust, if 2 years passes from that point and no action has been brought, then those assets become protected. And creditors have to act very quickly if assets are placed into a trust, and they have to, for example, bring a case in a court of competent jurisdiction. So that would probably be the US court within 1 year, and then in the Cook Islands within 2 years. So there's tight time limits that apply. It's a very protective jurisdiction.
And to add to that, I believe Cook Islands has a ability, or they prohibit amending claims. So if somebody starts a lawsuit in the Cook Islands and they realize they're coming after you for the wrong reasons, they can't amend a claim like they can in the United States. They have to restart their case entirely. And in doing so, there's a good chance the statute of limitations may have run during that time period.
Yes, that's absolutely correct, Blake. You've got to get it right from the start if you're bringing a claim there. So you've got to have all your ducks lined up in a row as a creditor, and you've got to be ready to prove your case when you go to the Cook Islands. You can't sort of lay a protective claim there, for example, just to get your foot in the door and then gather the evidence as you go on later.
And which we in America do allow, which we refer to as fishing expeditions. You start the process, you dig in a little bit, you see what it is you want to sue someone for, and then you rearrange, where that's not allowed in the Cook Islands. There's also a much higher standard of proof and proving and winning your case and proving a case in the Cook Islands. I believe it's a standard of beyond a reasonable doubt in order to win your case in the Cook Islands, as compared to America, where it merely requires a preponderance of the evidence. Do you have any comments on that?
Yeah, correct. That's so in certain areas, the trust legislation requires the court to be satisfied to that criminal standard of proof, to beyond a reasonable doubt, that certain things have happened in order for a creditor to prove their case. So a creditor has to prove beyond reasonable doubt that a transaction was fraudulent to a Cook Islands trust. So that means they have to prove beyond reasonable doubt that the primary intent of that transaction was to defraud them, that particular creditor. It's not enough for them to prove that it was, it was with the intention of taking assets out of the hands of multiple potential future creditors. Has to be specific to that creditor. They have to show beyond reasonable doubt that the disposition to the trust did in fact render the settlor insolvent and unable to pay again that creditor. So that there's a couple of very high hurdles that have to be cleared. And yeah, it's a stringent test that creditors have to pass.
And right, and to emphasize your point, there's certainly no rule against creating a trust for the purpose of protecting your assets. That came into being in 1982 with the Cook Islands passing their legislation. And the same principle is true in the United States since 1998 when Alaska passed their domestic asset protection trust law. You have every right to, unless you're under court order preventing you from it, but aside from that situation, you have every right to rearrange your financial affairs to minimize your taxes and to protect yourself from lawsuits. The domestic trusts have grown in some popularity in the United States. I tend to steer my clients more towards the offshore trust, and I do this for two reasons. One reason is it gives my clients better asset protection. If a plaintiff is coming up against a creditor, if a plaintiff is coming up against a client whose assets are secure in a domestic trust, it's going to be much harder for that plaintiff, for that attorney to get my client's assets than if the client's assets are using a domestic trust. And plaintiff attorneys know this, and they're going to be much more aggressive about going after domestic trust, and they're going to be much more willing to take a settlement offer with an offshore trust. So that's part one. It puts my clients in a better position. But the other reason that I like the offshore trust better is because it helps me to sleep better at night. It's a little selfish of me as well, but no, it's simply aligning my interest with the interests of my clients. So when setting up a Cook Islands trust, it's important not only to register it in the Cook Islands, but we also want to properly involve the trustee in the process. And I've never had a client lose any money with the Cook Islands Trust. And I think that is true for the vast majority of trust. Now, there are some rare and unusual cases where perhaps the settlor retains too much power over the trust, and that could put the settlor in a position where assets might be compromised. Do you want to talk a little bit about how to properly design and set up a Cook Islands Trust?
Yeah, there are a lot of ways to set up a trust, and there's a lot of different structures we see where through a variety of different means, the settlor retains a certain amount of control. So sometimes, you know, at one end, you've got the settlor placing assets into the trust, and then it's a sole trustee. There's a trust protector that isn't the settlor, that's maybe an independent company, and the settlor has really no control over those assets. Then you maybe move to a situation where the trust owns a company and the settlor manages the company and has day-to-day management of those assets. Then maybe we come to the other end of the scale and you have a situation where the settlor may even be a co-trustee and may have, you know, may be able to exercise all the powers of a trustee. Now, in and of themselves, none of these elements of settlor control make a Cook Islands Trust invalid. There's reserved powers legislation, it's called, in the Cook Islands, which means that a settlor can be a protector, a beneficiary, a co-trustee, you know, in the same way that domestic asset protection trust legislation in the US allow these self-settled trusts. What's important is the way the trust is operated after that. So if the settlor does really want to retain some control, they need to do that in conjunction with the trustee. They need to work with the trustee. If a settlor just cuts the trustee out of the loop, you know, manages the LLC themselves, makes distributions to themselves out of the LLC, retains this total control over the trust assets without having any regard to the trustee's role in that, there's a real and I think increasing risk that those trusts could be found invalid. There's been a body of case law over the last sort of 5-6 years in particular, which has shown that where a settlor is, you know, overly involved in the management of a trust, has too much decision-making power in the assets and exercises that power, those trusts have been, you know, struck down. They've been declared invalid by the court. And there's been, you know, there was a big case involving a Russian bank and settlor from 2017. That was Mezprom and Pugachev. And more recently, we've had a case involving it was a Cook Islands Trust, albeit a domestic one. The case is called Webb versus Webb. And that was another case in which the settlor was held to have too much power, and the court basically said, you made this look like a trust, but it isn't a trust because you've retained total control over it. And so it's just a bit of a cautionary tale for trust settlers. Don't go to the trouble and the expense of paying your attorney to set up this wonderful asset protection trust in the Cook Islands if you then manage it in such a way that it's going to get invalidated. You've kind of wasted your time and your money, and it's not going to get you the protection you need.
Yes, and I certainly agree with all of that. I mean, an aspect of creating a trust is having some element of trust in your trustee. Of anyone I've ever sent to Southpac or anyone I've ever sent to any of the offshore providers I work with, whether it's a trust company in Southpac or a banker in Switzerland, I've only received positive feedback. And the question that I get very often is, how do I know that my assets are safe? And I say, well, that's why you work with a licensed attorney. That's why you work with only the most reputable offshore providers. I will say that I spoke with years ago, Barry Engel, the attorney who wrote the Cook Islands Trust Law. And he said that in his career, one time he ever came across a trustee that actually mismanaged and stole some money. And this trustee, it was not a client of his, was out of Chicago. So it was not even an issue with an offshore provider. So thank you for all that. So let's talk a little bit about the asset side. So in terms of asset protection, there's two parts to it. One is getting control outside of the United States, and that's why we utilize the Cook Islands. But then there's also the aspect of removing the asset from physically being reachable by a U.S. court. If clients have real estate, will pretty much always, unless it's a primary home, suggest they put that real estate into an LLC and then put that into a trust. That real estate in a moment of a threat may need to be sold, or you may need to strip the equity out of it. Real estate not necessarily the easiest asset to protect. What I tend to use Cook Islands Trust for is to protect liquid assets. So with that, there's stocks, bonds, cash. And if you could talk a little bit about your relationships with the banks that you work with, in terms of how they play into the Cook Islands Trust structure. And if you could comment a little bit on any opportunities for clients with cryptocurrency and what they can do to put themselves in a better position to weather a lawsuit.
Yeah, sure, Blake. I mean, you're quite right. An offshore trust is better at protecting liquid assets than it is real property. You've got that. You can't pick up a house and move it to Switzerland, but you can put cash and securities there. So most of the banks and the custodians and investment managers that Southpac works with are based in Switzerland, although we do work closely with a bank in the Cook Islands called Capital Security Bank, and so they're kind of tied up to work with a couple of the investment managers that we work with, because if you're a US person and you're sort of looking to manage assets in offshore in a Swiss bank account, you need an SEC registered investment manager, and so there's a number of those that we work with that we can introduce our clients to. In terms of the banking options, so there's a number in Switzerland. For cryptocurrency, there is a bank called SIBA in Switzerland that offers a cryptocurrency account. There is also Bank Frick in Liechtenstein that we have connections with. So there are options coming online more and more now for regular accounts, if you like, that have a cryptocurrency dimension to them. And that's been of interest to a lot of clients, although obviously been a bit of a volatile time for cryptocurrency these last few months.
Yes, 2021, I would say maybe 90% of my clients were rushing in with big amounts of crypto that they just fell into. And now I still have probably 50% of my clients come in with some crypto holding. It's not as big of a demand for crypto asset protection as there was last year, but that's just kind of the nature of the crypto market. It's continually crashing up and crashing down. But clients have crypto that they want to protect from lawsuits. And there's some misconception that you can just lose your crypto in a boating accident, but doing so may require you to perjure yourself, and we'd never advise a client to take that course of action. What they can do is legally protect their crypto by working with professionals such as the two of us. Well, Matt, this has been a lot of fun. Last question I have for you today is if somebody wants to get in touch with you or the team at Southpac, what's your contact information?
Yeah, so if anyone goes to southpacgroup.com, that will bring up the website for our New Zealand office. You can see our profiles on there, see we're all real people, and we do have separate websites for the Cook Islands and Nevis offices as well. But generally, the way we're contacting our clients is through the New Zealand office. We've got the bulk of our staff here. We've got a team of attorneys here who work on client inquiries and help with the onboarding process. So yeah, look us up there, give us a call. We're we tend to be up pretty early so that we can be dealing with the US clients. It's 10 to 6 here now in the morning coming up, and yeah, this is around the time we're all starting to get going.
Well, Matt, thanks for giving me your freshest moment of the day, and thanks for being on the show. And I'm sure I'll be talking to you again very soon.
I'm sure, Blake. Thanks very much for having me. Been a pleasure as ever.